Minister Indranee Rajah.
Mr. Speaker, sir, Ms. Sylvia Lim had a couple of clarifications with respect to the amendment to the Constitution allowing monies to be transferred from the contingencies fund back to the consolidated fund. As Ms. Lim rightly noted, logically, there's no reason to object, but she wanted to know the process. She felt that it would be useful for the Minister to clarify the role of Parliament in the process and what form it would take and how members can participate. The transfer of funds from the contingencies fund to the consolidated fund or development fund does not involve the appropriation of funds for government spending. They merely reflect how we classify the government's resources for specified objectives in accordance with the laws governing each fund for the purposes of accounting and reporting. As such, it does not need to be specifically voted upon when we're returning it, and therefore informing Parliament is sufficient, given that Parliament initially authorised the top-up of the contingencies fund via the supply process. So in specific response to the question, the form it would take would be a miscellaneous paper from the Minister of Finance, which would be submitted to Parliament. I don't have the exact wording with me, but it will say something like X dollars, there'll be a reduction of X dollars from contingencies fund returned to the consolidated fund, and members can then, if they wish, ask parliamentary questions. That is the form that it would take.
Perhaps, Mr. Willem, we could take clarifications later. And where's Faishal Ibrahim?
Mr. Speaker, I thank the members for their support of the bills. I would like to first address an issue raised by Mr. Louis Ng on the use of presumptions in the MDA. As Mr. Ng pointed out, the use of presumptions and the application of more than one presumption acting on the same set of facts is not new under the MDA. We should remember that the fundamental reason for the use of presumptions in drug offences is because the facts which are being presumed are often exclusively within the accused person's knowledge. In the example given by Mr. Ng relating to having a key to a place, the presumption places the onus on the person found in possession of such a key to explain why he did not know the drugs were there, in spite of having the key to that particular place. Where there is no presumption, the burden is generally placed on the prosecution to prove a fact. Our long experience in dealing with drug trafficking syndicates is that without legal tools such as presumptions, drug traffickers would be able to evade legal responsibility by simply saying that they did not know the drugs were there or they did not know what they were carrying. The drug mules in the past and still today are trained to say certain things upon arrest. CMB knows this. The prosecution, despite having proven that the drugs were in the accused person's possession, are often not able to prove the accused person's knowledge of the drugs beyond a reasonable doubt, so long as he simply says that he did not know the nature of the drugs. The presumptions have been in existence since the introduction of the MDA in 1973, and they have worked well. Without them, we would not have been able to keep the drug trafficking situation in Singapore under control. We would also have otherwise only been able to punish people who came clean and confessed to the offences, while the guilty traffickers who lied to the authorities would go free. I would add that there are other presumptions which have also worked well for other drug offences, such as the presumption that a person whose urine test is positive is presumed to have consumed drugs. Legally, the presumptions can be rebutted, and historically, they have been rebutted many times. Whether the presumption can be rebutted turns on whether the accused's account is to be believed or not. He cannot simply say he did not know or he did not care. The facts or evidence required to rebut the presumption would very much depend on the nature of the defense raised by the individual and the credibility of his account. The issue of more than one presumption acting on the same set of facts has been raised in the past because the presumptions in the MDA presume different facts. More than one presumption can be triggered in respect of one set of facts. For example, if an individual possesses the keys to anything containing a controlled drug, he can be presumed to have that drug in his possession and also presumed to know the nature of that drug. However, the presumption cannot be used unfairly to prejudice the accused. For example, the presumptions of possession and knowledge cannot be invoked together with the presumption of trafficking, as these presumptions each serve a different function. The courts are careful to ensure that the burden on the accused is not so onerous that it becomes virtually impossible to discharge. The Court of Appeal has said that notwithstanding the use of presumptions, innocent persons can prove their innocence without any difficulty, whilst guilty persons cannot avoid liability by merely asserting a lack of knowledge without more, therefore undermining the general policy of the MDA itself. In fact, the courts have also said that the MDA presumptions strike an appropriate balance between the rights of the accused persons on the one hand and the rights of the persons in the wider society on the other, who would otherwise be adversely and directly impacted by the availability of drugs on the open market. Sir, turning to MPS specifically, while I understand Mr. Ng's concern, it is incorrect to state that the application of the MDA presumptions is more concerning when applied to MPS. The presumptions operate in the same way to presume facts that are especially within the accused's knowledge. In fact, the bill contains specific defenses for MPS that do not apply to traditional controlled drugs. For example, it is a valid defense for an individual to prove that the psychoactive substance is an excluded substance, or that he intended to use the psychoactive substance for a legitimate purpose other than human consumption. To address Mr. Ng's related question on this, an individual who claims that the substance is an excluded substance can either prove factually that the substance is an excluded substance, or where the section 18A subsection 2 presumption applies, prove that he believed and had reason to believe that the substance was an excluded substance. These defenses are not applicable to traditional controlled drugs. We believe our proposed approach straddles an appropriate balance between ensuring that those who are in possession of MPS for illegal purposes can be dealt with under the law, while at the same time ensuring that those who are innocent can show this without an unfair burden on them. On the same topic of presumptions, Mr. Zulkarnain asked about the safeguards in place to protect innocent landlords. During the investigation, CMB will establish who was in the possession of the drugs and how the drugs came to be at a particular location. Landlords who simply rent their premises to others have nothing to fear if they have given the tenant exclusive possession of the property. CMB or AGC do not simply prefer charges against people who own properties and rely on the presumptions to prove their case. In any event, as with controlled drugs under the current law, an innocent landlord can easily rebut the presumption of possession by proving on a balance of probabilities that the psychoactive substance was not in his possession. To do so, the innocent landlord could, for instance, point to the fact that a third-party occupier had full access and control over the property in question. Alternatively, if the innocent landlord was in possession of the item but did not know of its nature, he could then rebut the presumption of knowledge by, for example, explaining that he did not know that the item has a psychoactive effect when consumed. To address Mr. Zulkarnain's point about there being two separate presumptions of knowledge based on an initial presumption of possession, I should clarify that the new section 18A subsection 2 represents only one presumption of knowledge, namely knowledge that the substance is in fact a psychoactive substance. As I explained in my opening speech, the new section 22B provides that such knowledge comprises two elements. It is established if the person knew the substance had the capacity to have a psychoactive effect on an individual when consumed, and did not know or have reason to believe that the substance is an excluded substance. So I hope I have addressed all the issues about presumptions. Next, I would like to thank Mr. Derek Goh, Ms. Sylvia Lim, and Mr. Zulkarnain for their questions on the new control regime for MPS. As mentioned in my opening speech, with this new framework, all newly discovered psychoactive substances will be subject to the new legislative framework by default. And CMB can take action against persons dealing with them unless the substance is excluded under the fifth schedule. Specifically to address Ms. Sylvia Lim and Mr. Derek Goh's question on the processes undertaken by MHA before listing newly discovered substances under the first schedule or fifth schedule of the MDA, if a newly discovered psychoactive substance intended for abuse emerges in the local market or is identified for international control by UNODC, CMB will indeed seek to list it in the first schedule of the MDA. Before listing, CMB will work with the HTX and HSA to conduct rigorous testing and industry consultation to ascertain if the substance has legitimate purposes. If the substance is found not to have any legitimate uses, it will be listed as a controlled drug in the first schedule. This is the same approach adopted currently for substances we list under the first schedule. For example, in June 2022, we listed a synthetic cannabinoid in the first schedule after it was first detected in circulation in November 2021. This took approximately 8 months for the necessary testing, verification, and legislative amendments to be carried out. For completeness, to answer Ms. Lim's question, if MHA intends to eventually list all psychoactive substances that are found to have no legitimate uses and intended for abuse under the first schedule, the answer is yes, we do. We hope for the MDA to be as comprehensive in its coverage of these harmful substances. If the new substance is found to have legitimate uses or is regulated under other existing laws or regulations, it will be listed under the fifth schedule as an excluded substance. The frequency of such listing will depend on the emergence of new substances in the market. If a newly discovered substance is legitimately being used for scientific or medical research purposes, and this can be proven with supporting evidence, such research activities would not constitute offenses under the new regime. If, as in Mr. Zulkarnain's example, a person is found to have failed to comply with the expected standard in the handling of a psychoactive substance for legitimate purposes, like for medical research, they will not be prosecuted under the MDA. They may instead be taken to task by the relevant governing authority or ministry. To reiterate, the amendments are not meant to target legitimate substances or activities. Instead, it is aimed at psychoactive substances created for the purposes of abuse. On Mr. Goh's question of resource expended in verifying an accused person's defense that the MPS he is dealing with has legitimate users, I wish to emphasize that the current provision specifies that the accused bears the burden of proving on a balance of probabilities that the substance indeed had legitimate uses other than for human consumption. It will not be for CNB or the prosecution to prove or disprove his claim. This would prevent persons from attempting to employ such a defense without sufficient basis. Mr. Goh also asked if the new saliva test kits can detect MPS. Presently, the test kits deployed by CMB cannot detect MPS. While there are commercially available test kits that can detect certain classes of MPS, this would not be exhaustive due to the sheer number and diversity of MPS. The test kits used by CMB are meant as a screening tool and are able to detect the key controlled drugs that are commonly abused in Singapore. Nevertheless, CMB will continue to monitor the MPS trends, and with advancements in technology, CMB will be able to assess the feasibility of deploying more comprehensive test kits that are capable of detecting more MPS in the future. I cannot agree more with Mr. Goh's point on the importance of preventive drug education and keeping the public informed of NPS trends. Since the emergence of NPS abuse in Singapore, CMB has been proactively publishing informational brochures on NPS and their harms. CMB also engages the youth within schools and through those in positions of influence over youths, such as parents, counselors, educators, youth advocates, and national service commanders to educate them on MPS and their harms. I will also caution that if anyone is unsure if he is in possession of a psychoactive substance, he should undertake reasonable means to find out what is the nature of and the intended purpose of the substance in question. For example, by asking the person who gave him the substance. If the person continues to be unsure, he should report this to CMB or the police immediately. Mr. Goh asked about statistics of youths abusing MPS. In my opening speech, I provided MPS abuse numbers in the last 5 years. Mr. Goh may wish to refer to the annual statistics release published by CMB that provides a more detailed profile of drug abusers arrested by drug type, including MPS. We cannot afford to be caught on the back foot and only take action when MPS abuse becomes pervasive in Singapore. Ms. Sylvia Lim asked whether the amendments to introduce a tiered punishment framework for the drug possession offence are targeted at cases where the person are charged with trafficking, but the trafficking charge fails in court. The short answer is no. The question of whether charges would be preferred for trafficking or for possession would be determined by the facts as established by the investigation. Ms. Lim also asked for further justifications on why we need to increase the penalties for possession. CMB has observed in recent years that drug syndicates are smuggling larger quantities of drugs per transaction. We are concerned that this may drive up demand locally and may cause downstream law and order issues. Hence, that is why we want to be proactive to deter local possession of large quantities of drugs. Ms. Joan Pereira rightly pointed out Singapore's vulnerability to the threat of drug trafficking due to its transnational nature and asked if regional information sharing partnership can be enhanced and the role Singapore plays in committing some resources to such efforts. CMB actively participates in international and regional efforts for information sharing and operations. For example, CMB is part of the ASEAN Airport and Seaport Interdiction Task Forces, which provide platforms for enforcement agencies to collaborate and interdict drug trafficking in the region. CMB also works closely with its overseas counterparts to share intelligence, and this has resulted in significant arrests and seizures, both locally and overseas over the past years. In 2022, CMB also organized an inaugural workshop on Singapore's drug control strategy for our international counterparts to contribute to their capacity building and promote cooperation. Such cooperation has been crucial in helping to keep the threat of drugs at bay. Specifically for MPS, information sharing in the region has allowed countries to quickly list MPS for control once they have first been detected in one country. So this has been very helpful, right? Because we want to make sure that we protect everyone. And many countries would like to play a part in this and to see how we can reduce the harms to the people and prevent such happenings occurring in our jurisdiction as well. In fact, MHA and CMB plans to further its commitment to the international fight against drugs by seeking membership at the Global Commission of Narcotic Drugs for the 2024-2027 term. This will allow us to have a bigger voice in shaping international drug control policies and sharing our best practices on a global stage. Mr. Louis Ng also asked whether MHA works with MSF and social service agencies to ensure that children of drug offending parents are cared for appropriately. I will not go into a detailed reply as this topic has been discussed in the House before. In GIS, the answer is yes. There's currently a referral process between CMB and MSF. CMB officers can conduct early identification of family members at the scene of arrest and make the necessary referrals to MSF. Even if they remains a caregiver for the child after the arrest, CMB will still alert MSF as long as the child was at the scene of the arrest. So this is something that we have been enhancing, deepening, and our relationship with our agencies have become much better, and we are able to help more and more Singaporeans. Mr. Zulkarnain asked what MHA is doing in concert with HSA and other ministries to address vaping. This topic was discussed at MOH Committee of Supply Debates earlier this month. MHA works with MOH, MOE, HSA, and other agencies through the National Committee on Prevention, Rehabilitation and Recidivism, in short NCPR, to tackle the problem of substance abuse, particularly amongst youth. So this is something that we work together, right? And it's something that, if you look back at the history, something that we have been doing for many decades. And we will continue to enhance this effort. I would like to thank Mr. Christopher D'Souza for his strong support on the bill and for raising very important issues relating to our drug policies. We share his passion and commitment, and we are very happy to have someone like him journeying with us to keep Singapore drug-free. While we strengthen our enforcement framework against drugs with these amendments, MHA is still committed to ensuring that drug abusers receive the rehabilitation they require. Ms. Nadia asked if the government can provide more personalized support to recovering drug addicts. Similarly, Ms. Pereira asked if more comprehensive and long-term mental health resources and support could be offered to drug abusers who have gone through rehabilitation. MHA recognizes that ex-drug abusers need community support in order to successfully reintegrate and not relapse. Some ex-drug abusers struggle with mental illness or juggle multiple stresses, such as securing employment or managing strained family relationships. The Singapore Prison Service works with various community partners like the Singapore Anti-Narcotics Association, SANA, Singapore Aftercare Association, SACA, and religious social service agencies to provide continual pro-social support and engagement for drug abusers after their release. During the time that an ex-drug abuser is placed on CMB's supervision, the CMB supervision officer assigned to the ex-drug abuser will regularly check in on his or her well-being and assess their reintegration needs. The supervision officer will make referrals to social service agencies such as family service centers to provide further support for their mental, psychosocial, and other needs. As Ms. Nadia has pointed out, our current rehabilitation programs take a calibrated approach based on the individual's risks and needs. At the same time, CMB and prisons conduct regular reviews, including with MSF, to determine what more can be done to support ex-drug abusers in their rehabilitation. Ms. Nadia also asked if MHA would consider adopting harm reduction strategies. At the 2018 Committee of Supply debates, the Minister for Home Affairs has set out MHA's position concerning the harm reduction approach. Our position remains the same. As mentioned in my opening speech, we take a harm preventive approach. In Singapore, our tough laws have kept the drug situation here relatively under control, and so we must continue to keep drugs at bay to prevent the harms from overwhelming us. Harm reduction strategies have limited applications to Singapore's drug situation. Countries which adopt harm reduction measures are focused more on minimizing further costs from HIV or other blood-borne infections transmitted through intravenous drug use, rather than on preventing drug use, because they have reached a tipping point where drug use is too pervasive to effectively control. Singapore is not in a state where we cannot deal with the drug situation. Therefore, there is no benefit or need for Singapore to adopt harm reduction measures. Mr. Speaker, these amendments to introduce a new framework to regulate NPS and to increase the penalties for the drug possession offence reflect the Ministry's efforts to ensure that our drug laws remain an effective deterrent and to keep our drug situation under control. At the same time, as members have mentioned, we also focus on educating our public on the harms of drugs and adopting evidence-based approaches to rehabilitation and aftercare. Against the backdrop of a worsening global and regional drug situation, we must continue to press on our fight against drugs, to keep our streets safe and our families protected from the perils of drugs. With continued support from members in the House, our community partners, advocates, and members of the public, we will work towards maintaining a drug-free Singapore. Mr. Speaker, I'd like to thank you.
Are there any clarifications? Mr. Zulkarnain?
Thank you, Speaker. Thank you, MOS, for answering the questions. For clarity in my speech, when I referred to specific focus on youth, I was actually mooting for greater efforts on the part of MHA to prevent drug abuse amongst youth. I do have one clarification for MOS. Most of our PDE efforts for youth are in our schools and IHLs, but we need resources for parents to cope as well, especially with new drugs and NPS. What would the MHA continue to work with ministries and other independent bodies to help parents cope with these new drugs and new challenges that parents may face? In fact, I think CNB had a publication for parents previously called Start Talking Before They Start Taking. So maybe those resources can be updated and there can be a sustained effort for parents as well. Thank you.
So I thank the member for the SQ. As I shared in my answer, we have the NCPR platform that we not only look at efforts across agencies and the different community organizations. But we also look at some areas we want to focus. So one of the areas that we're looking at today is also about youth addiction issues, substance abuse, and that is one aspect. The other aspect, CMB, as you shared, has its own PDE efforts. And the efforts not only link with organization, but also looking at the different segments of the society, parents, students. Like in the last COS, MHF COS, I shared that the schools have committed to play a more active role in this aspect, working together with CMB, and we will try to see how we can enhance that effort. And another thing that we do is that if you look at CMB's social media platforms, they are very active. Right? We share various types of resources. One is about our operations. Whenever we make arrests, all this we will share. And secondly, we also share about the harms of drugs. I think recently, even Mr. Perdi Souza asked about how we can share further. And I shared that it's something that we will continue to do. Just about a few days ago, I shared about the harms of cannabis on my social media. And this is done inconsistent with what CMB does. So we plan all this holistically so that we try our best to reach out to the people who we engage and how we can reach out further with others that we may not have engaged. So going forward, we will also find ways, and we are exploring ways how we want to navigate this deeper and expand our outreach. Because at the end of the day, as I shared with you, with the global situation, I think the only way to go forward is to continue this journey, get as many partners as possible to be on board this journey, and protect as many people as possible, especially in Singapore, from the harms of drugs, and at the same time, keep our aspiration high of a drug-free Singapore.
Mr. Whelan.
Thank you, Speaker. I'd like to have a clarification about the MDA. Finance, I think I'll follow up separately after I've read in more detail what was said. My question actually to the MOS of Home Affairs is about, again, this interim period when the bill allows the enforcement agencies to proceed if a substance is found to have a psychoactive effect, even though it has not been listed yet in the MDA first schedule. And it was mentioned that during this period, there would be industry consultations and so on to determine if there has been any legitimate use for this product. And if there is a legitimate use, then it will not be listed in the first schedule. So my question is, will there be any risk that people are arrested, charged, or even sent for DRC, I'm not sure, based on the general definition of psychoactive substance, based on what they have, but eventually the substance, after due industry consultation, is found to have a legitimate use, and therefore it's eventually not listed in the first schedule? I mean, will there be such cases, and how would they be dealt with, you know?
So as I shared earlier, this is something not new. We also referred to overseas jurisdiction in the UK and Australia. And what I want to assure members is that we will have a robust and very careful analysis system. We work very closely with HTX, HSA, and in fact, since we shared about the need for our amendment, this amendment, a few years ago, we have been working very hard on the ground from the operational point of view, as well as our capability aspect in how we can detect MPS. And like what I said, MPS is ever-changing. What is key is that with the capabilities that we have built and those that we have detected before, we will be able to test quickly. But there'll be new ones where if we have not got any confirmation, we will not arrest the person. right? We will have to see how the structure of it and the psychoactive effect is confirmed, then we will be able to take any action. So in this case, right, we will look at with the new amendment, we will look at the psychoactive effect, right? So there are, from the scientific point of view, and also procedures involved to test the psychoactive effect, right? And once we do that, and we will be able to investigate further and work with the industry before we make and carry out any action. So I want to assure Ms. Lim that we will carry out a robust set of tests and consultation before we take any action. And this is consistent with the amendments that we make. We'll be looking at the psychoactive effects of the substance.
We'll first deal with the Misuse of Drugs Amendment Bill. The question is that the bill be now read a second time. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 45 stand part of the bill. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Home Affairs.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendment.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. As many as are of that opinion say aye. Aye. To the contrary, say no. I think the ayes have it. The ayes have it.
Misuse of Drugs Amendment Bill. Item 3, Constitution of the Republic of Singapore Amendment Bill, second reading.
Minister for Home Affairs.
Mr. Speaker, on behalf of the Minister for Home Affairs, I beg to move that I think
No, it's okay.
Mr. Speaker, on behalf of the Minister for Home Affairs, I beg to move that the bill be now read a second time. I have read this.
Question is that the bill be now read a second time. Pursuant to Article 5(2) of the Constitution, a vote is taken to ascertain that the second reading of the bill is supported by the votes of not less than 2/3 of the total number of elected and non-constituency MPs, which is 63 members. Clerk, ring the division bells. Sergeant at Arms, lock the doors. Before I proceed to start the electronic voting, may I remind members that they are to be seated at the designated seats and should only start to vote when the voting buttons on the armrests start to blink. The question is that the bill be now read a second time. Take a vote. You may begin to vote. May I remind members to depress the vote button firmly in order to register the vote in the system. Members are advised to check that the names are registered according to the vote indication when the voting results are shown on the display screens. Before I proceed to declare the results of the vote, are there any members who wish to claim that his or her vote has not been displayed or displayed incorrectly on the screens? I'll proceed to declare the voting results now. There are 67 ayes, 0 noes, 0 abstentions. The second reading of the bill has been carried by the votes of not less than 2/3 of the total number of elected and non-constituency MPs.
Constitution of the Republic of Singapore Amendment Bill.
Committee stage, what day?
Now, sir, I beg to move that Parliament will immediately resolve itself into a committee on the bill.
The question is that Parliament will immediately resolve itself into a committee on the bill. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. The question is that clauses 1 to 4 stand part of the bill. As many as are of the opinion say aye. To the contrary, say no. I think the ayes have it. The ayes have it. Bill to be reported. Minister for Home Affairs.
Mr. Speaker, I beg to report that the bill has been considered in committee and agreed to without amendments.
Third reading, what day?
Now, sir, I beg to move that the bill be now read a third time.
The question is that the bill be now read a third time. Pursuant to Article 5(2) of the Constitution, a vote is taken to ascertain that the third reading of the bill is supported by the votes of not less than 2/3 of the total number of elected and non-constituency MPs, which is 63 members. Clerk, ring the division bells. Sergeant at Arms, lock the doors.
Doors are locked, sir.
Question is that the bill be now read a third time. Take a vote. You may now begin to vote. Again, reminder to members to depress their vote firmly in order to register their vote in the system. Members are advised to check that the names are registered according to the vote indication when the voting results are shown on the display screens. Before I proceed to declare the results of the vote, are there any members who wish to claim that his or her vote has not been displayed or displayed incorrectly on the screens? I will proceed to declare the voting results now. There are 67 ayes, 0 noes, 0 abstentions. The third reading of the bill has been carried by the votes of not less than 2/3 of the total number of elected and non-constituency MPs.
Constitution of the Republic of Singapore Amendment Bill.